I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back, everyone, to the Prosecutor's Legal Briefs. I'm Alice, and I'm joined, as always, by my enchanting co-host, Brett.
Oh, enchanting. I have cast a spell over you, Alice. And forced you to say nice things about me.
Well, there you go. I mean, kind of on that theme of, a spell of going on the same path, we have a riveting topic today, Brett. I know something that all of you are just on the edge of your seat waiting for, and I'm not kidding about this, because once we start talking about it, I think you will see why it's riveting, and that is the law of precedent.
Precedent, yeah. So we've talked a lot about Supreme Court cases on this podcast, and in pretty much every, not just Supreme Court case, but a lot of the cases we've talked about, at some point, we've talked about a decision getting overruled. So, for instance, if you think about, we talked about dual juries. That came about because of a precedent that got overturned. And you see the Supreme Court do that sometimes. And people who are not lawyers, they don't really understand how that works. And we've got a lot of questions about how does all this work? If they can just overturn something at any time, how can you ever feel like you have any security in the law or what the law means, which are all great questions. And so we decided, let's talk about precedent and how it works.
Yeah, absolutely. And, you may have heard the word precedent. You may have heard stare decisis. You may have heard binding precedent and all these terms that are being thrown around. And we want to kind of just tease out what each of those terms are when you hear them on the news or you read them in court opinions. So what is precedent? We've talked about how our judicial system is one of common law. And what that means, it's not codified. We don't get to kind of plug in a code to whatever legal problem you have and outspits the answer, right? Input A plus input B, you have problem C, you're always going to get answer D. That's not how our jurisprudence works. Rather, it's common law based on reasoning and looking to previous courts' reasoning. And over the course of time, a body of law develops with kind of reasoning based upon reasoning. And that body of law is called precedent.
And as Alice said, sometimes it's called different things. You might hear it called case law, which just means it's law created by cases. They're out there being decided. And the Supreme Court decides case law, it decides ultimate questions of law. And then the lower courts are bound by that. So whether they agree or not, they are bound to apply it. Sometimes you'll hear the difference between persuasive and binding precedent. You have precedent not just at the Supreme Court. We have a bunch of circuit courts in this country. They cover different states. We have, I think, 12 really circuits, 11 numbered in the D.C. Circuit. We also have the Court of International Trade and the Federal Circuit. But those are kind of, don't tell the judges of those circuits, but they're not real circuits. So really we have 12 real circuits. And when they make a decision, the lower courts are bound by them. So for instance, if you're in the 11th Circuit, which is Alabama, Georgia, and Florida, the 11th Circuit makes a decision and you're a district court judge in Florida, you have to apply that. If the 8th Circuit makes a decision, say a case comes before you and there's a question and you have no idea what this is all about, right? And the litigant says, well, look, this is brand new. There's no law in the circuit, but the 8th Circuit looked at this question and they came to this conclusion. Well, that's a circuit court. It's a higher court than you, but it's not your circuit, so it's not binding, but it is persuasive. And circuit court opinions are often very persuasive for district court judges because they assume when the 11th Circuit, in this instance, hears that, they're going to say, well, there's already been a circuit look at it. That's a pretty good argument for that's how it should come out. And district courts don't like to be overruled, so that's powerful. But it's only persuasive. It's not binding. In whatever court is above you, when it makes a decision, it's binding. If you're in a state and your state Supreme Court makes a decision, it's binding on the lower courts. And that's binding precedent that really does make a difference about what the law is in whatever court you're in.
And what binding precedent means is if a lower court makes a ruling that is against their binding precedent, so a court that they are bound by, you know you will be reversed because that is kind of acting against the rule in that circuit. Now, you might be thinking, well, you just told us there were, about 12 circuits, and even if your circuit hasn't addressed a particular area of law, there's not binding precedent, you can look to other circuits. What happens when there are different results or different opinions on the same legal issue coming out of different circuits? So let's say the 11th Circuit and the 10th Circuit are both on equal levels in that they are federal courts of appeals, but they could reach a very different answer on the exact same legal question. That is what we call a circuit split. And so if you've heard that term in the news or wherever, that's what it means. It just means that two circuits have reached different answers on the same legal question. So if you're in, say, the Ninth Circuit, and the Ninth Circuit has not dealt with that legal issue, you may look to the 10th and the 11th Circuits that have reached it. But here you have two circuits of the same level, so to speak, that are persuasive on your court in the Ninth Circuit, but you're not bound by them. So typically what you do is you raise the fact that there's a circuit split and you argue the opinion that you think has the best reasoning. Now, the reason this matters is when there's a circuit split, usually what will happen over time is this legal issue will probably develop in other circuits, and they will look to these opinions and kind of side with one side or the other. And if it's a particularly kind of contentious or just unclear area of law, you may have like a very, very split issue where it's like split, 50% of the circuits come out one way, 50% come out the other way. And in those types of cases, those are kind of the types of cases that are primed for U.S. Supreme Court review, because that's the role of the Supreme Court. They're above all of the courts, all of the lower courts, state and federal, and they are kind of the supreme law of the land. Typically, like the way over time the Supreme Court has wanted law to develop is for there to be at least several circuits to have considered the issue before they take it up. And you can imagine why. They get to have the benefit of hindsight to see how certain decisions play out over time, how the reasoning develops from circuit to circuit, that sort of thing. So kind of explaining some terms you may have heard.
And as Alice said, that's a big trigger for the Supreme Court to take a case. We talked about this before. 75, 80 cases a year is all they take. So they don't take very many. But if you do have a well-developed circuit split, so you've got a couple circuits on one side, a couple circuits on the other, it's a weird thing if you think about it. The law applies differently in different places depending on what circuit you're under. And the Supreme Court will allow that to continue for a little while, as Alice said, for the arguments to develop, for judges to take a look at it. I mean, just imagine how much better it is if you're a Supreme Court justice. It's not just the two people arguing in front of you. You've got all these judges who've written these opinions, who've made their arguments for why something should be interpreted in a certain way. It can be very helpful. And at some point, usually the court's going to deal with that circuit split because this notion of having the law applied differently in different places is anathema sort of to our system. Give you an example of how this happened and why it's important. You guys probably remember the Affordable Care Act, Obamacare. It got challenged under the Commerce Clause, and the first court that considered it said it's not ripe, which just means it's not ready. More things need to happen before we can consider this. The next court said this is a ripe challenge, but this is constitutional under the Commerce Clause. Well, if nothing else had happened, maybe the Supreme Court doesn't even take it. But then another court says, nope, challenge is ripe, and this is unconstitutional under the Commerce Clause. So now you have this national piece of legislation that's been declared unconstitutional in one court and constitutional in another. The Supreme Court had to take that case and ended up taking it, and very interesting and different and not Commerce Clause decision came out of that. But in any event, that's sort of an example of when the circuit split really matters and drives the Supreme Court to do something. Now, this is different from some terms you guys might have heard of. Precedent is different from res judicata, which is a fancy Latin term, which means law of the case. That means it's a thing that's already been decided in your case. So if you have a lawsuit and you lose a motion and then later on you file another lawsuit, you don't get to re-argue that motion. The law of your case is you've already lost that motion. That applies to your new lawsuit. That's different. But this is about big picture decisions on legal questions, which are now going to be binding in all future cases. And you can either, if you're a judge and the Supreme Court makes a decision, you can either just apply it directly. You can try and distinguish it, which is the work of judges in a lot of cases. The Supreme Court and the decisions it makes are often very broad. They're very high level. They're about legal principles. And oftentimes it's difficult for the Supreme Court to imagine all the factual circumstances and legal circumstances that are going to apply to that particular decision. So a lot of the work of courts is distinguishing what exactly they're doing. The Supreme Court itself or a circuit court, when it hears a precedent, a new case, challenging precedent, they can modify it. They can tweak it a little bit and say, hey, we didn't get it all right. We're going to keep this precedent. Or ultimately, they can overrule it. They can say, yes, this has been the law. And at some point, at least 5 justices of the Supreme Court thought this should be the law. But we, sitting now, are going to say, or in the case of a circuit precedent, we are going to sit en banc, so the entire court, and say we're reconsidering that precedent and we are overruling it, which obviously is a big deal. But it's not maybe as rare as you think. It's somewhat rare. It certainly doesn't happen every day.
Brett, let me break in real quick because I think there may be a misconception. Is it prohibited that precedent be overruled? Is there a rule against overruling previous cases or previous decisions or lines of reasoning?
There's not a rule. There is a principle called stare decisis, which means generally speaking, the presumption is going to be we are going to stand by whatever has been decided in the past. So the presumption, how heavy that presumption is, who knows? But there is a presumption that something that has been decided, and we're not necessarily going to change that decision. There's a tweak on this. Constitutional decisions, the Supreme Court and other courts often will reconsider because constitutions being what they are, they're big, they're broad, they're not easily changed. If the Supreme Court or another court gets it wrong on a constitutional question, that's a big deal and it's hard to deal with. Statutory questions, the court almost never changes its position. So if Congress passes a statute or a state passes a statute and the Supreme Court interprets that statute in a certain way, usually that's like not going to be revisited for the simple reason that if they got it wrong, Congress can go back very easily and say, no, court, you misinterpreted what we were trying to do. So here's what we were trying to do. Get it right next time.
That's a great point, Brett. And just to kind of put it into perspective for you guys as to how often constitutional precedence is overruled, in the 225 years or so of this country, the Supreme Court has overturned a constitutional precedent around 150 times. So it's less than once a year. Of course, the vast majority of these are probably really in the last 100 years. So it's not like this one-off thing or even two-off thing. It happens less than once a year. So it is rare, but it is not unheard of. But that raises the question as to why you can overrule precedent if there's this principle of stare decisis. You want people to know what the law is, right? It's important for the legitimacy of the court, for people to understand how the courts or how the laws will be applied to you. There's nothing that says we have to listen to the courts. Their legitimacy kind of comes from their reasoning and being able to use their rational thinking and explanation to explain why this is the correct result, the just result. So with that said, precedent comes in an opinion that carries with it a reason. And when can you, or what principle are you supposed to follow when you overrule precedent? And also, before we even get there, why can you overrule precedent? Well, there are kind of a few thoughts to this. For one, we do have a common law system. And so nothing is really set in stone. Rather, it's kind of evolving amoeba of the law in a way, right? There aren't these definite boundaries for the most part. There are exceptions. We've talked about this in a lot of the criminal law, rules of evidence. We've talked about this in your First Amendment rights, even your Bill of Rights. There are exceptions and carve-outs because we are this moving body of law. And one thing that we want to avoid in this common law system is the problem of the dead hand of the law. And that's essentially that there's no movement. One decision, let's say one bad decision in the past, rules us for all time, even if we can definitively show how that was the wrong result, whether it's faulty reasoning or whatnot. You don't want to just be stuck in the past when you have better information or you've seen how an opinion has borne out over time. And for a democratic country, as is the United States, it's actually kind of an anti-democratic nature of precedent, right? Because there's this problem of it's a decision that was made before. And so even though times have changed or, populations are changing and who lives in it and how we interact with society and new developments within the world as we know it, if it's not taken into account, the law can be very rigid and kind of become antiquated quickly.
Yeah, and I think Alice made a couple points there that are worth amplifying. Number one, the fact that the courts, one reason they stick to precedent and they need to stick to precedent is this notion of legitimacy. The fact of the matter is the judiciary has been called the least dangerous branch because all it has is the power of reason. That may seem strange to you, but think about it. The people who execute the court's orders are not the judiciary, they're the executive. And at some point, everyone has to agree that when the court speaks, we're going to listen to them. It's one of those weird things in any kind of society. Institutions are so important and trusting institutions are so important because at some point things break down without that. At some point, the law doesn't matter and what's written on a piece of paper doesn't matter. What matters is that everyone agrees that we're going to do that. There's that story, probably apocryphal, about when the Cherokee Nation in Georgia and other places in the South had sued to stop the removal of Cherokee Indians west into the Oklahoma Territory during what came to be called the Trail of Tears. And they pursued this all the way to the Supreme Court and won. And Andrew Jackson supposedly said, Justice Marshall has made his decision, now let him enforce it. And that's sort of the ultimate danger with the courts. If the courts are not respected, at some point, the whole thing kind of falls apart. And that's one reason precedent is important. And this other thing that Alice said, the anti-democratic nature, sort of on the other side of it. It's really hard. Once the court says something about the Constitution, that's just the way it is. And it really doesn't matter what most people think about it. If you want to change a constitutional decision of the court, you have to amend the Constitution. This has happened before. The 11th Amendment is an example of this, where the Supreme Court made a decision and very quickly the Constitution was amended to overturn that decision. But that is super rare. It's happened after a civil war. The 13th Amendment, 14th Amendment, 15th Amendments essentially overruled Dred Scott. But generally speaking, if the Supreme Court doesn't change their mind on a constitutional question, that's just it. The supermajority that you need to change the Constitution is very anti-democratic in that way. And we are a Republican democracy, so that does matter. This dead hand of the law thing, just this notion that decisions made 10, 20, 30, 40, 100, 150 years ago prevent you from adjusting to current problems. Those of you who are either religious or maybe you just like to read Bible stories, there's this sort of trope in the Old Testament about the law of the Medes and the Persians. And in the Old Testament, these kings of Babylon and Persia, they're always getting tricked by somebody. And they get tricked into doing some sort of law that sounds really good at the time, but they don't realize it has some nefarious purpose. But the laws of the Medes and the Persians couldn't be changed. So once you made the law, that's the law forever and all time. And so inevitably, as soon as they make the law, they realize, oh, this terrible thing's going to happen. But it works out in the end. But in any event, you don't want that. That's actually not a good thing. You don't want to have laws that can't change. And because this is law in a very real way, it's not passed by Congress, it's not signed by the president, but it's law in a very real way, there needs to be some way to revisit it in the future.
Right. And so when do we get to revisit it in the future? Well, there's a couple questions to ask. First question, is it wrong in the first instance? So when it was decided, was it wrongly decided? Not just hindsight. Now we look at it, applying it to our changed circumstances now. It no longer applies. Was it wrong in the first instance?
And a good example of that might be Plessy versus Ferguson. I think most people agree that Plessy versus Ferguson, when it was decided, was obviously an incorrect interpretation of the 14th Amendment, basically wrote the 14th Amendment out of the Constitution in a lot of ways. And so when the Supreme Court came back 50, 60 years later in Brown versus Board of Education, they didn't have a whole lot of qualms about overturning it because they believed they didn't even get it right then. And so they didn't even get it right then. That makes it much easier for the court to say, we're just not going to give this case a lot of respect.
Right. And for those of you who may not be familiar with Plessy versus Ferguson, it was the Supreme Court decision that said segregation laws did not violate the Equal Protection Clause of the 14th Amendment. And so you can see how if it's wrong in the first instance, it's not even considered precedent, right? It's just a black mark on your history in that you don't have to follow something that was clearly an ink blot. It was wrong. And so that makes the inquiry a lot easier if you can say it was wrong in the first instance. But second question, what if it wasn't wrong in the first instance? Because we're not relegated to only, reconsidering precedent or analyzing whether it should be reconsidered if it wasn't wrong in the first instance. So the other instance is, have developments in the law come to render continued reliance on the precedent problematic? So in other words, you made a decision back then, it wasn't wrong, but because of that decision, it has just become an incredibly unworkable system.
You got to remember, we're talking about rightness and wrongness here, but just because a precedent is wrong isn't enough. So that's an important thing to know. These are just the first questions. The first question is just, is it even wrong? Obviously, if it's not wrong, we shouldn't be overturning it, right? even if you disagree with it, or if you have a policy issue with it, or whatever, if it's not wrong, we shouldn't be overturning it. This second question is much more complicated because it's like maybe it was wrong when you decided it, but it wasn't that wrong, or it hasn't been that big of a deal, or it's kind of worked out. And we're going to walk through those factors that flesh this out some. But just know that wrongness alone is not enough. So even if you decide it was wrong when it was decided, or it was questionable when it was decided, that doesn't mean, okay, well, we're good. It was wrong, overturn it. That is not what you do for all the reasons we've been talking about. Being able to trust the courts, you want to have some stability. So the first question is it wrong? But then you get into these other questions. It's almost like, is it wrong enough? And is its wrongness going to mitigate any of the consequences of overturning it? So, you could have a decision that's wrong, but overturning it's actually going to be worse than just leaving it in its wrongness to stay a part of the law. You've decided you think the court made an error. Put yourself, you're a Supreme Court justice now. You decided that the court has made an error in some way. Should this be something we overturn? Well, the nature of the error is the first thing. It's kind of wrapped up in these first two questions. Just how wrong are we talking here? And what were the consequences? Some of this is going to be wrapped up in the other factors we're going to talk about. We've already mentioned Plessy. Plessy is a good example. So you've got a situation where you have a Civil War. Well, first you have Dred Scott, which basically says, and we'll probably talk about Dred Scott later on, but basically says that if you're an enslaved person, you can never be free because people who live in the slave states have a due process right that can never be violated, and therefore Dred Scott's not a citizen and he really has no standing in slavery forever, is basically what Dred Scott says. So you then have a Civil War, which sort of overturns Dred Scott. But then after the Civil War, you have a number of amendments, the 13th Amendment, the 14th Amendment, and the 15th Amendment, which were intended to deal with Dred Scott and solve the problems that Dred Scott had made obvious in the Constitution. This is really complicated, so I'm not going to get into the details of all of it right now, but just know it's basically, we want to have equal protection of the laws for people regardless of their race. We want to make sure that freed slaves are going to be equal under the law. So give it, 30 years. Plessy comes up and you have someone who says, hey, I've got this equal protection right. The trains are segregated, and by operation of law, I'm being arrested if I get on a segregated train, and I'm not allowed to do this. That seems like a violation of my constitutional rights. And somehow the Supreme Court, in a 7-1 decision, 7 justices were like, nah, that's not what the 14th Amendment meant. It meant something else. So basically, because they didn't want it to mean that, right? I mean, at the end of the day, they were like, do we really want this? This is not what we want. Let's not do this. Let's just say it didn't mean that. And so for 50 years, it didn't mean that. And then in Brown versus Board of Education, you have basically the same question, but we're not talking about trains anymore. We're talking about education. And the Supreme Court says, man, that was wrong. And it was so wrong. And it was so obviously wrong at the time. This is an egregious error. And because it's an egregious error, we are more apt to overturn it.
Right. And another factor to consider is the quality of the reasoning, because we've talked about how these court opinions are based on reasoning, right? There's the holding, but the holding is kind of the punchline, the conclusion. What matters is also the reasoning that gets you there, because there's many avenues to get to the result. And so there's good quality reasoning, there's bad quality reasoning. So what makes a decision good? Well, first of all, sound reasoning, but also how grounded in case law is it? Or how grounded in the Constitution is it? Is it kind of trying to pull at things that don't really exist in the case law as is up to that point? Are they having to really read or parse through language in the Constitution to create something that's not really there? Was it consistent with the laws up to that point? Or did it seem to work kind of an about-face, a revolution in the law at that time? Did it seem to take a complete break from what all the other laws and all the other court decisions and other kind of corollaries in the law lead to? And if it was this complete about-face in the law, a complete revolution, how was it received?
And a good example of this is Miranda. So, and let me just say, cases that become the center of an attempt to overturn them, precedents that are shaky and are often attacked, usually are revolutionary. Whatever it is, usually seems like it kind of came out of nowhere, and it did a lot. I mean, that's, if you just look at them, if you think about the ones that have been overturned recently, typically they tend to be these sort of really big decisions, because big decisions have some weaknesses in them. They can seem to come out of nowhere. If you read a Supreme Court case, the average Supreme Court case, it is dry and boring because it's just this long historical treatise on everything that ever happened, going back to the English common law and the British and what they were doing, and Blackstone and what he wrote, and what the founders thought, and what happened in the first few years after the Constitution was ratified, what the states were doing, how many states did this and how many states did that. And it's just this sort of building to an almost, the conclusion they want you to draw when you get to the end of it is, so obviously we're going to do X, right? Because it's so consistent with everything else. And so this question has really been answered already. We've just never said it. I mean, that's what the Supreme Court, half the time, it feels like they're saying. This has already been decided. We've just never made it explicit. Now it's explicit, right? But then you have cases like Miranda, which kind of come out of nowhere, right? So Miranda, all of a sudden, the police have been not telling people their rights for essentially the entirety of the country because they didn't think that was their job. You have a right to remain silent. You can either remain silent or not, and that's up to you. I'm not your lawyer, right? I'm not going to tell you that. And at some points, the Supreme Court decided, it would be better if you did. I mean, it was really just a pure policy decision. It'd just be better if you did. So we're going to have a prophylactic rule. We talked about this. It's going to just protect your rights. So we're going to make it up, and we're just going to say you have to do this, and this is the way we're going to enforce it. Go forth. And Miranda, at the time, was super controversial. People hated it. Like half the tropes for movies going after Miranda were how somebody got off on a technicality. The whole notion of getting off on a technicality is basically from Miranda. If you watch Nightmare on Elm Street, right? There's a point where Freddy Krueger, he kills like all these kids and he gets arrested, but there's some technicality and he gets off. And so the parents have to take it into their own hands, right? I mean, this is just a trope. And so people really hated Miranda at the beginning, and there was a big push to overturn it. But over time, it actually became pretty much accepted. Probably because of police procedurals. People heard that phrase, the Miranda warnings. They heard it again and again and again. And suddenly it just became part of the country. It's not in the Constitution, but it's just part of the fabric of the country. And famously, Justice Rehnquist wanted to overturn Miranda. It was one of his big things. And then Congress passes a law and says, hey, Miranda's not a constitutional rule, so we can pass a law. We can restrict it. And then this was the opportunity for the Supreme Court to overturn Miranda, because that gets challenged. It goes up to Supreme Court. It's directly opposite of Miranda. And the Supreme Court, with Rehnquist, is like, no, in a case called Dickerson, you can read it. It's like, no, this had some problems, but everybody's accepted it. It's just part of society, so we can't get rid of it. And you essentially had justices who believed it was wrong, believed it was wrongly decided, who nevertheless, because even though it did sort of work this revolution, it ended up becoming part of the fabric, and tearing it out would be worse than leaving it in. Even if you disagree with it, like taking it out would have just been this shattering thing and would have confused people and would have confused the law. And so Miranda stays.
Now, Miranda is such a commonly known phrase. It's in every TV show. It seems like kids know what the Miranda warnings are. It's helpful for people to remember that when it was declared, law of the land by the Supreme Court, it was a complete revolution and it was not accepted. So it's really helpful to know. And not all decisions have had that same kind of effect over time. Some have stayed a revolution or controversial.
I mean, Miranda has become so accepted that you have people writing scare tactic articles about how the Supreme Court just restricted Miranda. It's just, that's how fundamental it has become. People think their, 28th Amendment Miranda rights are going to be violated. And it's just, that's how ingrained it is. And that's important. So Alice talked about quality of reasoning. Another thing we look at is workability, which kind of goes along with this. Can the opinion be understood and applied in a workable manner? Is it easy for lower courts to apply? Is it easy for legislatures to legislate around? Do lawyers understand it? Is everybody able to say, don't agree with that, do agree with it, but you know what I can do? I can work with it. Now at least I know the rule. That's an important thing. If it's something that causes confusion, if it's something that's never really accepted, if it's something that's constantly causing more and more litigation, it can become a problem. An example of this you guys will never have heard of was a case called Payne versus Tennessee, which overturned a prior case about victim impact statements, of all things, right? So victim impact statements, there had been a ruling by the Supreme Court that victim impact statements were not allowed to show blameworthiness. So you couldn't use your description of the victim to increase the blameworthiness of the killer. So imagine somebody's on, we'll use killer because it's always a good example. Imagine this is a death penalty case, deciding whether or not to execute somebody. You might think, someone who murders the mother of 4 is more blameworthy than someone who murders their drug dealer, right? You guys can debate that in the comments. But the Supreme Court's like, you can't get into that. No, you can't do blameworthiness. But you can do evidence of harm. So you can show that by murdering the mother of 4, it affected the other 4 children, and therefore the case was more heinous, and maybe they should get a higher sentence. If you can figure out the difference between blameworthiness and evidence of harm, congratulations, because nobody else could. The courts couldn't figure it out. Lawyers couldn't figure it out. Supreme Court couldn't figure it out. So when it came back to the Supreme Court, they were like, we don't know where blameworthiness ends and harm begins. I'm sure we had the best of intentions when we did this, but it just hadn't worked out. It's completely unworkable. We're getting rid of it. From now on, you get up there as a victim, you say whatever you want, which is essentially the rule now. And that's an example of this workability coming into play.
Right. And another factor is the effect on other areas of the law, because, law doesn't just get siloed in one area. We are a common law that draws upon reasoning and analogy from one area of law to the other. So is the precedent undermining other areas of the law? Makes it inconsistent with how other areas of law have developed. And this is a wonky one, but is it causing other unrelated rules to change? So is there kind of that unintended consequence of this particular opinion? After all, the whole point of stare decisis is to give some predictability to the law. Remember, we talked about the legitimacy of the court, and part of the legitimacy is knowing what the law is, be able to predict what the law is. But if this opinion somehow changes, an unrelated rule, that creates a lot of instability and a huge problem.
And some good examples of this are like standing or mootness or ripeness. Justiciability, whether the court can actually consider something. So think about it this way. The court that passes a rule, or it has a holding, a constitutional holding, and that has all sorts of effects. And various people who are affected by that, there are laws being passed and people are challenging things. But for whatever reason, just imagine that under the court's ordinary standing rules, so the court has all these standing doctrines. And standing just means I am somebody who can challenge a case. in the United States and a lot of places, not just anyone can decide to challenge a law or a constitutional provision. You have to have standing. So, an example of this might be if you're a citizen of California and Maine passes a law and you try and file a lawsuit challenging Maine's law, it's probably going to be hard for you to show you have standing because the law doesn't apply to you. You need to show some sort of harm to you that can be redressed by the court. As we've said in previous episodes, the court doesn't just decide it's going to address a problem because somebody says this is a problem, we should address it. You need to have standing. Well, imagine you've got this constitutional rule, but because of the standing doctrine, nobody actually has standing to bring challenges to it or to help refine it or to help define things that the court has left undefined. Well, the court might start changing its standing doctrine to allow people in what's supposed to be a narrow instance to come make arguments in front of them they wouldn't normally be able to make. And that starts to undermine all your standing doctrine. And at some point you might say, why are we doing this? Why are we undermining all of our other precedents just to protect this one? This one is a problem. We need to do something to protect all our other precedents. That's a really wonky one, but it is something that the court considers. Another one that's really important is reliability. Reliance, not reliability.
I mean, one who reliance is about reliability too. But that's a great point, Brett. Reliability. That's really important because have the courts and legislatures enacted whole schemes on the basis of this precedent? In other words, have people just depended their decision making on this opinion, on this precedent? Do people live their lives assuming this legal rule will remain in effect?
And once again, Miranda's a big one, right? I mean, Miranda is such a good one because I don't know. I'm sure there's people out there who are shocked every time I say this, but Miranda's clearly not correct. Miranda is a decision of the Supreme Court where they were just like, we're just going to be philosopher kings for a little while and say it would be better if this were the rule. Man, it would have been great if this had been the Constitution. So let's just say it is, right? I mean, that's what they did. And if you read the opinion, it's basically what they're saying. But the fact of the matter is, it works. People have come to rely on it. And it's been accepted. And it's just one of those opinions that even if it's wrong, it shouldn't be overturned. And it's not overturned. And it won't be overturned. And I think it's really interesting and good for these reasons. Reliance, if ordinary people are out there living their lives with the expectation that this rule is going to be the rule going forward, the court should really think about it before they change it. Sort of an opposite side of that was a case, one of the worst cases ever decided called Kelo, where the Supreme Court, it was in Connecticut, and for the first time, a private company wanted to use the power of eminent domain to take people's property and use it to build their own thing. It was Pfizer, I believe. So Pfizer was going to build this big plant in this little town in Connecticut, and so they took all this property, the state took all this property and gave it to them. And the Constitution says it has to be public use. So if you're going to take somebody's land, it needs to be for a public purpose. So you're going to build a road or, whatever. And the step was, well, yeah, but think about it. They'll move in and there'll be more jobs and there'll be more taxes. And that's a public purpose. So even though we're just giving it to a private company, that's fine. And the Supreme Court said, yeah, we're going to do that. That's not overturning a precedent, but it's extending a precedent. They never said that before. Certainly, most people thought they could rely on the constitutional guarantee that their property wouldn't just be taken from them and given to a corporation. But Coda owned this. Immediately after all this happens, Pfizer gets the land, the economy collapses, they never do anything, and now it's just like this empty place where they took all these houses, they took all these people's homes, they bulldozed them all, and it's just nothing. So, practical effect of a bad Supreme Court decision. But in any event, this is really important, and reliance is something that the court comes to look at. A practical sort of case that we've talked about where all of this comes together, not so much overturning precedent, but an applying precedent. We talked about a couple weeks ago, the West Memphis Three, and we talked about this testing of DNA, right? So what's happening there? You have a statute, and the statute says, this is when you test DNA, these are the circumstances, this is under the habeas statute, blah, blah, blah. And a lot of people just could not understand why the court didn't just, number one, didn't just order DNA testing. Or number two, there's this one part of the statute that's clearly about something else, but nevertheless mentions not being in custody. And so they're like, see, this part of the statute says not being in custody. So therefore, you don't have to be in custody for habeas. Stuff like that. Well, that's where precedent comes in. Because if you look at the precedent's very clear. You have to be in custody to have habeas. So you don't just start with the statute and then read the statute and interpret the statute for yourself and say, well, that's the law. You have to look at precedent. And that judge was bound by that precedent. They couldn't just start with the law either. They had to start with the rules that had been established. And a good lawyer is trying to distinguish that precedent. We talked about that earlier and say, well, this is a completely different circumstance. So yes, there's precedent. It's bad for us, but here's how it's distinguished because this is a different situation. And maybe they'll go to the Arkansas Supreme Court, who does have the power to change precedent and overturn precedent. And the Arkansas Supreme Court may say, you're right, we're going to modify our precedent and say that in this circumstance, you don't have to be in custody. And then that lower court judge will then have the authority and the power to do something different. But if she does, it will be because someone decided at a Supreme Court level that our past rules no longer account for changes in the statute, changes in the way things are done, all the sort of things we've talked about. And these interests that we've talked about line up. So we are going to say our prior precedents, wrong, we're going to change them. This is the new rule. So that's how it works, not just at the Supreme Court, the United States Supreme Court, that's where you see it, but really at every level of the law in the United States.
So there you have it. Clear as mud, I'm sure. In other words, there is no, surefire way to know when you can overturn precedent. But we've kind of listed some factors that the courts consider when the courts do look at precedent. And again, because we're talking about the highest levels, this is typically going to be your courts of appeals, the state Supreme Courts, the U.S. Supreme Court, since they are the ones who have the power to overturn precedent. So we hope you've enjoyed this incredibly law nerdy episode, but a lot of you have been asking about this. So we hope we've answered some questions, defined some terms that you may have heard before. And if you have any questions or we were completely unclear, then please let us know because we always love hearing from you. So, Brett, is there anything you'd like to add before we sign off?
The only thing I'll say is this is yet another 45, we went long this time, 45-minute episode of an entire law class, at least one entire law class. So hopefully it was somewhat informative. I'm sure people are going to have questions. We'll try and continue to work through this as we talk about other things in the future.
Absolutely. Well, thank you guys. And please, keep letting us know how you think about these. Email us at prosecutorspod@gmail.com. Visit us on all of our platforms, Twitter, Facebook, Instagram, and also please make sure you rate, give us a 5-star review if you like this, leave a review so others know how to find us. And also, if you're interested in our other podcast, the Prosecutors Podcast, where we cover true crime story more fulsomely, not just law updates, then you may check us out there as well. But until next time, we are so happy you guys joined us. I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs.
Okie dokie.
So we are talking about precedent today.
Precedent on precedent. Precedent squared. Okay. I mean, I'm surprised anybody listens to this podcast.
They seem to listen to it. You read them in court opinions and why it's important. So that was a weird way of saying important. Why they're important.
Just thought you were really putting the emphasis on the right syllable there,